Paul, thank you for joining us. When you see the ruling that was made today, what does it mean to you?
Well, it's great to be on with you all. And what it means for Coinbase and really for all of us in the industry is that courts once again are stepping in to provide regulatory clarity where the SEC has refused to do it. This was a unanimous opinion. You had a very strong analysis written up by Judge Rao, joined by Judge Edwards and Chief Judge Srinivasan. It just shows again that the SEC, when it acts contrary to law, without regard for developing common rules and standards, is going to find itself held accountable in courts of law.
Now, I know that nobody here has a crystal ball, but in your own dealings with the SEC, do you expect that they would just take this, or do you expect them to put up more of a fight when it comes to either this rulings or rulings like it? I mean, there are a lot of outstanding lawsuits when it comes to how it's dealing with the crypto industry.
Well, there's certainly been no shortage of resolve on the SEC's part, and it's true that in this case, you could see a request for further rehearing en banc or even a petition for cert review by the Supreme Court. But I think the wiser course, the better course, not just for the SEC, but for the industry as a whole, is for the SEC to take a pause and to take to heart the lessons that the DC Circuit was encouraging it to consider in this ruling. Yes, it's possible that on remand, the SEC could come up with new reasons, new excuses why this product should be, or this conversion should be rejected. But it's also an opportunity, I think, for the commission to acknowledge that its course of action, its approach to regulating crypto isn't working. It's not too late to get this right. We think this offers an excellent opportunity for the commission to take a pause on its approach and adopt a much more productive, much more effective means of bringing clarity and certainty to this market.
Okay, but Paul, to your point about maybe the SEC could find another way to poke holes in the case for a spot ETF conversion on the part of Grayscale, or really just a spot ETF in general, does it become an issue of something like custody or surveillance sharing, so other concerns that they have raised?
Well, they could raise those concerns. I think surveillance sharing in particular is one where the industry has anticipated that argument and responded to it. We've seen agreements proposed, including those involving Coinbase, by other applicants. I think it's time for the SEC to take a break and to pause and reflect on why its approach to regulating this market hasn't worked, and what are the underlying concerns that it's trying to address and should be addressing. Surveillance sharing agreements are certainly one way to manage that. I think the better course, though, is for the SEC to engage in a dialogue with the industry rather than relying upon court actions in order to resolve these questions.
Perhaps explain a little more, given that Coinbase is a big part of so many of these surveillance sharing agreements, SSAs for short. What is the case for those surveillance sharing agreements to kind of bolster the argument for approval for these ETFs?
Well, the fact of the matter is that we are confident that these surveillance sharing agreements with the listings exchanges can effectively mitigate or reduce the risk of market manipulation. And of course, the standards that would apply would be the same standards that apply to other asset classes with ETFs. So we do think these agreements can be an important part of the solution. Of course, Coinbase has a significant role to play as a custodian. There are just better, more effective ways to address the concerns that the SEC has raised than simply rejecting these applications out of hand and relying upon court decisions in order to set standards.
What about Coinbase's business model? There's a lot of debate. On one hand, you see Coinbase soaring in the market right now on the heels of this decision. On the other hand, you have some analysts like Mizuho kind of pointing out here that the emergence of an ETF could really long-term make a difference when it comes to fee structures, when it comes to to crypto trading. How do you think about this holistically?
Well, for Coinbase, the opportunity lies in growing access to the crypto economy as a whole. And so to the extent that exchange traded products bring other market participants into crypto and offer another way for investors and consumers to safely and effectively participate in the crypto economy, we think that benefits Coinbase. The fact of the matter is that there is plenty of opportunity for all participants, and we welcome additional ways in which investors and consumers can participate in the crypto economy. We think that's a win for Coinbase as much as anyone else in the industry.
So, Paul, obviously, Coinbase has been dealing with its own litigation with the SEC in regard to allegations that it was operating an illegal securities exchange by having unregistered securities, quote unquote, on the platform. Of course, that was really the question with XRP as well, the idea of the definition of a security. It feels like there's still a lot of legal murkiness around it. Where do you think your case stands now, given some of the other cases we have seen and the indications of the direction that courts are heading in regard to some of the SEC questions?
Well, to be very clear, we think that the best long-term solution looking ahead is still comprehensive federal crypto legislation. Of course, we're very encouraged by the bipartisan momentum we've seen in the House recently on that issue. But while we wait for legislation, we remain very confident in our position in our case with the SEC. The fact of the matter is that in the XRP case, and even in other cases that have followed, courts have rejected the fundamental claim by the SEC that these digital assets are themselves securities. Instead, what they've said is, let's look to the transactions involving those assets and assess them in that manner. And we think that as courts look at this type of approach, adopt this type of approach, they're going to find that, particularly when it comes to secondary trading on exchanges like Coinbase, the federal securities laws, as currently drafted, do not apply. It's one of the reasons why we think new legislation could and should be adopted to address the underlying concerns that we share with the SEC.
Something to think about here, too. And Paul, I want to put a little context here. You have worked at nascent technology companies before Facebook, prior to Coinbase. When you're kind of looking at the evolution of the industry, both from your perch at Coinbase and as a member of this crypto industry that is really just burgeoning, what's the roadmap? How are you looking at these cases from XRP to your own case? And what are the uncertainties you need to have clarified immediately?
Well, it's certainly the case that anytime you're dealing with disruptive technologies, you're going to have instances or situations where litigation may be necessary in order to resolve outstanding questions. But litigation is no substitute for comprehensive legislation, and that's why we are so supportive of the bills that are pending in the House right now that would, for example, confirm that these digital asset tokens are not in and of themselves securities, as the courts have already held, that would provide for a path to registration so that cryptocurrency exchanges like Coinbase can come into the regulatory perimeter and fully comply with the legal standards that are applicable here, even as we look to offer digital asset securities in the future. So confirming a path to registration, confirming a sensible, workable definition of securities that distinguishes between the vast majority of assets that are not securities and those that may be, we think that that type of clarity is critical for long-term certainty for the market. And that's why we're working on these issues with the Congress and even with the SEC itself, even as we continue to believe that in our court case, we will win.